Madam, we have nothing personal agenda with any appointment in this government. But the fact is the way the government has been transgressing the domain of legislature is a matter of serious concern. The fundamental question is whether legislature will prevail upon executive or not. Yes, there is a plethora of instances where ordinances were issued since the independence. But when our Honorable Prime Minister was seen bowing down to the temple of democracy, he should not be seen in kowtowing his ego by restoring to an ordinance route. This is my humble submission to this government. It is because heaven would not have fallen upon you had that appointment been done through the regular legislative way. You are an eminent lawyer. Even you were happened to be the member of Joint Parliamentary Committee for examining the telecom scam. You are the party that stalled this House weeks together for the constitution of that joint parliamentary committee and that every TRAI chairman was examined there. It is your government, it is NDA government that in the year 2010 had amended the TRAI Act to rule out the appointment of chief regulators in any central and state governments. So now the question is that the day the person was appointed, he was not at all qualified for that appointment. But in spite of knowing the statutory disqualification of the same person, what had warranted you to bulldoze the golden path of legislative procedure that needs to be considered upon. Not only that, it was conceptualized and passed in a lightning speed. It smacks of a little hidden agenda. I would like to know whether the PMO was unaware of the statutory hurdles of that appointment. Once it was highlighted, you did not want to eat the humble pie. You restored to the ordinance route. Through this way, you were liable to trampling upon the golden path of democracy and restoring to the outrageous path of ordinance. Your government has set out its legislative journey by way of ordinance. This would not augur well for any democratically elected government. Honorable Speaker, please address the chair. Why are you directly attacking the minister? You can attack through me. Madam, I do not have the courage to attack anybody. I do not want to be restricted from the house. Madam, may I ask one question? Should an ordinance be restored to appoint an individual for a post? It is admissible. I do not question the integrity and honesty of an individual. We have never cited the issue of integrity, but only integrity cannot be the sole criteria of promulgation of any ordinance. Should an ordinance be issued to overturn the intents of the legislation? Again, I am highlighting the intents of the legislation enacted in the public interest. The legislation as enacted in the public interest. The intention as to prevent nepotism, and the intention was to ensure transparency. Should an ordinance be issued to overturn the intents of the legislation enacted in the public interest? Madam, it could be the first instance in the annals of Indian legislative institution where a government at the center promulgated an ordinance even before proving its majority on the floor of the House. I know it is incidental. You had objected many ordinances brought by UPA government, for example the Food Security Act, the anti-corruption legislation, etc. But here, forgetting everything, you have introduced your maiden legislation through an ordinance. Madam, I am simply drawing the attention of the Honorable Minister and this House that this kind of ordinance should not be brought in such a way. We are not against the ordinance, but the way one individual has been preferred to offer an appointment through the ordinance route cannot be substantiated by any argument whatsoever. That is why I am opposing vehemently to this kind of a legislation which has been brought through an ordinance. I hope that reason will prevail upon this government and it will shun from pursuing this ordinance route, because ordinance can be promulgated only on extraordinary situation. This government cannot substantiate what kind of extraordinary situation had arisen out which warranted this government and which called for this kind of ordinance. So I hope that this government will reconsider and follow the formal legislative way to appoint any personality. Madam, they are referring to other financial institutions where this kind of restriction has not been imposed. That is right, but we are not preventing the government to bring the same legislation for all the regulators, chairman, competition commission, chairman, SEBI, etc. They are saying that there is some provision for other regulators which is not available in this TRAI case, and nobody has prevented them from bringing the same legislation on par with TRAI. This government should not resort to this kind of ordinance simply on the pretext of other regulators.